All right, hey there, y'all. Welcome back. This is going to be lecture 4C, speech in colleges. And sadly, there's not really anything on protests. I'm kind of disappointed in that, but there's some interesting stuff here. But um, I was a little disappointed given the current state of protests on campuses all across the country, and the anti-Semitism and sometimes the false claims of anti-Semitism and the police and the, riot gear and all of this kind of stuff and arrests and expulsions, and colleges don't really know how to handle it. And, at UCLA, I guess last week, cops just sort of stood back and let these two groups just beat the shit out of each other for like 3 hours. A lot of injuries. So that kind of stuff is really concerning. Anyway, so let's dive into it. Case number one is Healy versus James, and this is a unanimous 9-0 reversal, and Justice Powell delivers the majority opinion. All right, so the context here is that students at the Central Connecticut Community College want to form a chapter of a group called the Students for Democratic Society. The Students for Democratic Society was sort of a anti-Vietnam, white supremacy, pro-civil rights, etc. They were causing a lot of stir on campuses, starting riots, starting protests, setting fires, taking over buildings, etc. And so there was concern by the university at Central Connecticut that this SDS group would be involved with sort of the national organization. So the college basically says, all right, you can do that, but you can't be associated with the national organization in any way. And the student body says, oh, all right, we'll do it that way. However, when they sent the application to the president of the university, he rejected it outright. Um, and the students sued, claiming that they were denied their First Amendment rights of speech and association. Um, the lower district court said, yes, they were denied due process, basically, because the president considered, ideas outside of the realm of any of the other groups in their application process. And so they said, well, you have to, go through the application process and do it right this time. It went back to the president. He denied it again, and it went back to court. The lower court dismissed it. The appeals court dismissed it. But the Supreme Court picks it up and reverses the lower courts, and they basically rule for the students for the Democratic Society or whatever, the SDS. And they say at the outset, we note that state colleges and universities are not enclaves immune from the sweep of the First Amendment. So just because you're a college doesn't mean that you can, restrict First Amendment rights as much as you want to. They also say, however, where state-operated educational institutions are involved, this court has long recognized the need for affirming the comprehensive authority of the states and of school officials, consistent with fundamental constitutional safeguards, to prescribe and control conduct in the school. So you can restrict, speech and behavior in some senses, so long as you're trying to, protect the safety of the school. Because of the acknowledged need for order, First Amendment protection should apply with less force on campuses than in the community at large. There can be no doubt that denial of official recognition without justification to college organizations burdens or abridges associational rights. The primary impediment to free association flowing from non-recognition is the denial of use of campus facilities for meetings and other appropriate purposes. Moreover, the organization's ability to participate in the intellectual give and take of campus debates and to pursue its stated purposes is limited by denial of access to the customary media for communicating with the administration, faculty, and other students. Such impediments cannot be viewed as insubstantial. It is to be remembered that the effect of the college's denial of recognition was a form of prior restraint. So again, this is going sort of to the New York Times 1973 against the U.S., the Vietnam papers, right? Prior restraint. This was a form of prior restraint, denying to petitioners' organization the range of associational activities described above. While the college has a legitimate interest in preventing disruption on campus, which, under circumstances requiring the safeguarding of that interest may justify such restraint, a heavy burden rests on the college to demonstrate the appropriateness of that action. And then they say, okay, the school basically gave four possible justifications for rejecting the application of the SDS. And they say three of those are inadequate constitutionally. They must be struck out. And one might be adequate, and we would like to kick it down to the lower courts for further consideration. Okay, number one, association is not constitutional. They say the government has the burden of establishing a knowing affiliation with an organization possessing unlawful aims and goals, and a specific intent to further those illegal aims. Not only did petitioners proclaim their complete independence from the national organization, but they also indicated that they shared only some of the beliefs its leaders have expressed. On this record, it is clear that the relationship was not an adequate ground for the denial of recognition. So they're not going to uphold that part of the associational argument from the school. Number two, philosophical differences is not constitutional. The mere disagreement of the president with the group's philosophy affords no reason to deny its recognition. Okay. Number three, speech versus conduct. This is maybe constitutional. The line between permissible speech and impermissible conduct tracks the constitutional requirement, and if there were an evidential basis to support the conclusion that the SDS group posed a substantial threat of material disruption in violation of that command, the president's decision should be affirmed. The record, however, offers no substantial basis for that conclusion. So they're saying, okay, if the group is saying they're going to be violent or they're going to burst into classrooms and that kind of stuff, yes, you can stop that sort of behavior and reject their membership. However, there's nothing in the record to suggest that this group did that. Okay, number four, unwillingness to participate by the rules. And this is the one they say is probably constitutional, and that lower courts, they want to kick it back down to the courts to think about this further. They say, these same references in the record to the group's equivocation regarding how it might respond to issues of violence and whether it could ever envision interrupting a class suggest a fourth possible reason why recognition might have been denied to these petitioners. These remarks might well have been read as announcing the petitioners' unwillingness to be bound by reasonable school rules governing conduct. The regulation, carefully differentiating between advocacy and action, is a reasonable one, and petitioners have not questioned it directly. Yet their statements raise considerable questions whether they intend to abide by the prohibitions contained therein. So they're saying there was some worrying equivocation about violence and interruptions in the statements of the SDS members. So that's worrying. Then they go on and say, just as in the community at large, reasonable regulation within respect to the time, place, and manner in which student groups conduct their speech-related activities must be respected. A college admin may impose a requirement, such as may have been imposed in this case, that a group seeking official recognition affirm in advance its willingness to adhere to reasonable campus laws. Such a requirement does not impose an impermissible condition on a student's associational rights. And finally, they say that SDS must be given another hearing. Then they say, we note in so holding that the wide latitude accorded by the Constitution to the freedoms of expression and association is not without its cost in terms of the risk to the maintenance of civility and an ordered society. Indeed, this latitude often has resulted on the campus and elsewhere in the infringements of the rights of others. And so they're saying, while we do need to be concerned about colleges interfering in people's rights to freedom and association, we cannot have disordered society, and we cannot have you infringing on the rights of others on your campus. All right, case 2, Papish v. the Board of Curators, 1973. This is a 6-3 reversal, and it is a per curiam decision. So, a grad student, a young woman, a grad student at the University of Missouri in the journalism school, is expelled for, quote, distributing on campus a newspaper containing forms of indecent speech in violation of a bylaw of the Board of Curators. And the board of curators at the university give two reasons for expelling this young woman. She published a newspaper with a political cartoon that showed cops raping the Statue of Liberty and the Lady of Justice. And then she published an article, I think it was the same issue of the newspaper, which was titled Motherfucking Acquitted. And it was about, some New York violent case with the police. And the student conduct committee had a hearing and they expelled her. And so she sued in district court and was denied. And then she appealed to the appeals court and was denied. But the Supreme Court granted her cert. And they said, we think Healy makes it clear that the mere dissemination of ideas, no matter how offensive to good taste, on a state university campus may not be shut off in the name alone of conventions of decency. Other recent precedents of this court make it equally clear that neither the political cartoon nor the headline story involved in this case can be labeled as constitutionally obscene or otherwise unprotected. Coy versus Wisconsin is the one they cited. Excuse me. Since the First Amendment leaves no room for the operation of a dual standard in the academic community with respect to the content of speech, and because the state university's action here cannot be justified as a non-discriminatory application of reasonable rules governing conduct, the judgments of the courts below must be reversed. Accordingly, the petition for a writ of cert is granted, the case is remanded to the district court, and that court is instructed to order the university to restore the petitioner all course credits she earned for the semester in question, and, unless she is barred from reinstatement for valid academic reasons, to reinstate her as a student in the graduate program. So they're just completely ruling against the University of Missouri. They're saying not only have we said before clearly that curse words are not a violation of the First Amendment, but also that you cannot, but also that political cartoons are not a violation of the First Amendment. So, your case is completely crap. Okay, case 3. Rosenberger v. Rector and the Visitors of the University of Virginia. These case names get ridiculous. Okay, vote is 5-4 reversal. And Justice Kennedy delivers the majority opinion. So, the University of Virginia has a policy where they pay publishers and distributors to publish and distribute student newspapers. And the University of Virginia withheld payment for one of the student papers for, quote, the sole reason that their student paper primarily promotes or manifests a particular belief in or about a deity or an ultimate reality. And so this sort of a Christian newspaper sues on First Amendment grounds for free speech and establishment clause. They basically said the student activities that are excluded from the SAF support, the Student Activity Fund support, are religious activities, philanthropic contributions and activities, political activities, activities that would jeopardize the university's tax-exempt status, those which involve payment of honoraria or similar fees, or social entertainment or related expenses. So those are like the rules of what we will and will not fund. And Rosenberger runs a group called WAP. I shit you not. It stands for Wide Awake Productions. And their basic philosophy states to publish a magazine of philosophical and religious expression, to facilitate discussion which fosters an atmosphere of sensitivity to and tolerance of Christian viewpoints, and to provide a unifying focus for Christians of multicultural backgrounds. Okay. So the university ruled that they could be a student um, organization, and that it was not a religious establishment, that it was just a sort of editorial piece about religion. But then, after they had established that, they refused to pay those SAF bills for their publication. And so the lower courts held that it was clearly discriminatory and that University of Virginia, but that University of Virginia had a necessity to avoid Establishment Clause problems. But the Supreme Court disagrees. They say the university itself has taken steps to ensure the distinction in the agreement each CIO must sign. Having offered to pay the third party contractors on behalf of private speakers who convey their own messages, the university may not silence the expression of selected viewpoints. The viewpoint discrimination inherent in the university's regulation required public officials to scan and to interpret student publications to discern their underlying philosophical assumptions respecting religious theory and belief. That course of action was a denial of the right of free speech and would risk fostering a pervasive bias or hostility to religion, which could undermine the very neutrality of the Establishment Clause requires. There is no Establishment Clause violation and the university is honoring its duties under the Free Speech Clause. So, they got to pay up. UVA has to pay up. Okay, case number 4. The Board of Regents of the University of Wisconsin versus Southworth. This is in 2000. It is a unanimous 9-0 reversal, and Justice Kennedy delivers the majority opinion. And it's a pretty big one. So, the students of the University of Wisconsin brought a First Amendment challenge to a mandatory student activity fee, right? You have to pay it as part of your tuition. Imposed by the Board of Regents of the University of Wisconsin and used in part by the university to support student orgs engaging in political or in ideological speech. Respondents object to the speech and expression of some of the student organizations. Relying upon our precedents, which protect members of unions and bar associations from being required to pay fees used for speech the members find objectionable, both the district court and the Court of Appeals invalidated the university's student fee program. The university, however, contends that its mandatory student activity fee and the speech which it supports are appropriate to further its educational mission. They say, we reverse. The First Amendment permits a public university to charge its students an activity fee used to fund a program to facilitate extracurricular student speech if the program is viewpoint neutral. We do not sustain, however, the student referendum mechanism of the university's program, which appears to permit the exaction of fees in violation of the viewpoint neutrality principle. As to that aspect of the program, we remand for further proceedings. Okay, so the University of Wisconsin collects these fees to support on-campus group services, speeches, debates, etc. Some student groups have to register as what's called an RSO, a registered student organization. And the rules say to qualify for RSO, status students, to qualify for RSO status, students must organize as a not-for-profit group, limit membership primarily to students, and agree to undertake activities related to student life on campus. So some pretty basic rules. And fees can be obtained by these RSOs for things like debates and student activities in one of 3 ways, right? The first way is to go through what's called the Student Governing Activity Fund, the SGAF. The second is to go through the General Student Services Fund, the GSSF. And the third is through student referenda, where the students vote on whether the debate or lecture or whatever should get funding or not. And the Supreme Court says that third one is probably not constitutional, right? It's a tyranny of the majority problem, where the majority will just reject, alternative ideas. And so they say this is unconstitutional, and so we're going to kick this back down to the lower courts to kind of mull over for a while. And then they say, in March of 96, respondents, each of whom, remember what year this is, right? This is 2000, so this took 4 years to go through the courts. In March 96, respondents, each of whom attended or still attend the university's Madison, Wisconsin campus, filed suit that imposition of the segregated fee violated their rights of free speech, free association, and free exercise under the First Amendment. They contend the university must grant them the choice not to fund those RSOs that engage in political and ideological expression offensive to their own political beliefs. Then they say, the university may determine that its mission is well served if students have the means to engage in dynamic discussions of philosophical, religious, scientific, social, and political subjects in their extracurricular campus life outside the lecture hall. If the university reaches this conclusion, it is entitled to impose a mandatory fee to sustain an open dialogue to these ends. The university must provide some protection to its students' First Amendment interests, however. The proper measure and the principal standard of protection for objecting students, we conclude, is the requirement of viewpoint neutrality in the allocation of funding support. Rosenberger v. Rector and the Visitors of the University of Virginia. When a university requires its students to pay fees to support the extracurricular speech of other students, all in the interest of open discussion, it may not prefer some viewpoints to others. So, as long as you're not sort of discriminating about which group gets to speak and which does not, which makes that sort of referendum problematic, then it's fine to require students to pay a fee to sort of bolster free speech and free expression and free thought and scientific, innovation and etc. So, okay, case number 5, the the Christian Legal Society chapter of the University of California, Hastings College of the Law versus Martinez, 2010, and this is a 5-4 affirmation. Justice Ginsburg delivers the majority opinion. And the question here is, may a public law school condition its official recognition of a student group and the attendant use of school funds and facilities on the organization's agreement to open eligibility for membership and leadership to all students? Okay. In the view of the petitioner, the Christian Legal Society, which is a law school group that they want to have official recognition. In the view of the petitioner, Christian Legal Society, an accept all comers policy impairs its First Amendment rights to free speech, expressive association, and free exercise of religion by prompting it, on pain of relinquishing the advantages of recognition, to accept members who do not share the organization's core beliefs about religion and sexual orientation. From the perspective of respondent Hastings College of the Law, CLS seeks special dispensation from an across-the-board open access requirement designed to further the reasonable educational purposes underpinning the school's student organization program. So, this sort of Christian organization objected to the idea that they had to allow either homosexuals or non-Christians or etc. Into their ranks according to school rules of anti-discrimination. The concern here is, where do you draw the line, right? Can they say that only white people can be members? I don't know. That's sort of, again, the sort of reductio ad absurdum argument when you take things as far as they can go in that argument, give worrying concerns, right? And so the Supreme Court says, no, this is really problematic, your argument here. To be registered as a RSO or a student organization, school-approved groups must, quote, allow any student to participate, become a member, or seek leadership positions in the organization, regardless of status or belief. So that's the rule of the University of California's law school. And it says CLS chapters must adopt bylaws that, inter alia, require members and officers to sign a statement of faith and to conduct their lives in accordance with prescribed principles. Among those tenets is the belief that sexual activity should not occur outside of marriage between a man and a woman. CLS thus interprets its bylaws to exclude from affiliation anyone who engages in, quote, unrepentant homosexual conduct. CLS also excludes students who hold religious convictions different from those in the statement of faith. So those are the rules of this student organization that they're worried about. They say the U.S. District Court for the Northern District of California ruled in favor of the law school. The law school's all-comers condition on access to a limited public forum, the court held, was both reasonable and viewpoint neutral, and therefore does not violate the CLS's right to free speech, and the Supreme Court agrees. Okay, so that's the final piece for this little lecture. And then we're going to move completely into a new topic and talk about sort of desegregation, Jim Crow, um, separate but equal in the next section. All right, so y'all have a great day, and I'll see you for the next.